current matter before the court is a case between A, B, and X as applicants against the state Surya as respondent. Each side has 45 minutes to present their case, and first counsel for the applicant is requested to come forward.
Good afternoon, Your Excellencies. If it pleases the Honourable Court, my name is Alice Eccles, and I appear before you on behalf of the applicants, X, A, and B, alongside my learned co-counsel, Miss Emma Rowland. There are 4 issues before the court today. I will begin by addressing issues A and B, which pertain to the alleged violation of the applicant's right to privacy under Article 17 of the International Covenant of Civil and Political Rights, or ICCPR. My co-counsel will then speak to issues C and D, which relate to the alleged violation of the applicant's right to freedom of expression under Article 19 of the ICCPR. If it pleases Your Excellencies, I will speak for a time of 21 minutes, my co-counsel will speak for a time of 22 minutes, and we will reserve 2 minutes for the purposes of rebuttal. Your Excellencies, following complaints made under 220 and Section 300 of the Syrian Penal Act, the Syrian state made a warrantless request for personal data pertaining to both X, A, and B, subsequent to which the applicants were charged and convicted under those sections. Your Excellencies, X, A, and B are Syrian citizens who have exercised their internationally and domestically protected right to freedom of expression. The heavy-handed response that this elicited from the state has made a mockery of both the right to privacy and the right to freedom of expression. Whilst it is recognised that neither of these rights are absolute, where both are fundamental to the proper functioning of a democratic society, it is submitted that their violation should only be condoned in the most limited of circumstances. Limited circumstances, it is the applicant's submission, which do not here arise. Your Excellencies, I will structure my submissions as follows. First, I will demonstrate that Syria's actions amounted to an interference with both X's and A and B's right to privacy. Second, I will demonstrate that said interferences were carried out in such a way as to be both unlawful and arbitrary. Turning to my first submission, namely that Syria's actions amounted to an interference.
Counsel, just to clarify, so you're questioning the arrests based on invalidity per se or an as-applied threshold?
Your Excellencies, I am challenging it on an applied basis. Thank you, Your Excellency. The test for establishing an interference with the right to privacy is set out in General Comment number 16 is set out in the Human Rights Committee decision of Tunin in Australia, taken in 1994. It requires an affirmative answer to the following 2 questions. First, does the right to privacy apply to the information and behaviour in question? Second, does the state's actions interfere with the right? With regards to the first of these 2 questions, it is the applicant's submission that the right to privacy does extend to personal data of the type acquired by the Syrian government. This is so where General Comment number 16 at paragraph 10 makes clear the applicability of Article 17 to personal information, or more commonly personal data. The committee does not provide a definition of the term personal data, but is being consistently defined by bodies such as the Economic Community of West African States and the European Union as any information relating to identified or identifiable natural persons. With this definition to hand, Your Excellencies, it is common sense that A and B's right to privacy extends to A and B's telephone number. It is equally common sense that X's right to privacy extends to X's identity. It remains in question whether X's right to privacy extends to A and B's telephone number. Your Excellencies, it's the submission of the applicants that X's right to privacy does so extend. In this regard, I would direct the Court's attention to the European Court of Human Rights case taken in 2018 in Benedict and Slovenia. Just as in the instant case, in Benedict and Slovenia, the Slovenian police, without first obtaining a court order, requested a Slovenian internet service provider provide the personal data associated with a dynamic IP address that had been implicated in the sharing of child pornography.
Counsel, can I ask you a question there? So you've mentioned a European case. What are your thoughts on how this court might interpret the doctrine of margin of appreciation in relation to this matter?
Your Excellency, it is the applicant's submission that the Human Rights Committee, which is the principal adjudicator of disputes under the ICCPR, has not only not invoked the doctrine of margin of appreciation, it has in fact explicitly rejected it in several circumstances, both in relation to Articles 19 in General Comment number 34 at paragraph 36, and in relation to Article 27. With this in mind, it is submitted that the margin of appreciation is not here appropriate in relation to Article 17, as we are here discussing. My pleasure. To return to the case of Benedict and Slovenia, following the request made by the Slovenian police, the service provider gave the police the name of the applicant's father. After a search of the family home, the police indicated that it was the applicant and not his father that was the suspect. The court held that the applicant's right to privacy, as protected by Article 8 of the European Convention, had been violated. Of particular importance, as regards the instant case, is the holding of the European Court of Human Rights at paragraph 113 of that judgment. Namely, the fact that the personal data obtained from a service provider is that of a subscription holder and not of other users of that subscription is of little significance where personal data relates not only to identified but identifiable individuals.
Can I just take you back a step there? You mentioned Article 8. Would you mind just clarifying the distinction between Article 8 and the relevant section of the ICCPR for me?
Absolutely. Your Excellency, it's submitted that there are differences between Article 17 and Article 8, especially with regards to the language that is used in relation to a person's private home and similar. What is at issue here, though, is a question of personal data, and it's submitted that Article 8 and Article 17 similarly apply when what is at issue is personal data specifically.
But was this personal data coerced by the government? Did they exercise any force, or was it voluntarily surrendered by a private entity?
Your Excellency, it was voluntarily provided by a private entity. It is the applicant's submission that this voluntary provision does not allow the state to pass on its obligation to only interfere with the applicant's right to privacy on a lawful basis. It is submitted that the request made to hire was unlawful where there was no application for a judicial warrant. If Your Excellency would allow me to move on to my second submission so as to expand on this lawfulness point, of course.
About the legal warrant, since you already mentioned, is that an absolute requirement that the legal warrant has to be always issued? Do you know any exceptions for that?
In relation to the Criminal Procedure Act in Soraya specifically. So it is noted, and I'm sure my learned counsels will point to the fact at clarification 7 that the term enable is used rather than require. It is submitted that there should be no exceptions for the need to require a judicial warrant in view of the balancing act that is needed to be taken when assessing the necessity and proportionality of interfering with an individual's right. It is submitted where we are beginning to move into this question of hire's actions in relation to the state, that the state failed to discharge its positive obligations under Article 17. Per General Comment number 16, at paragraph 1, the positive obligations on the shoulder of the state, as assured by Article 2 and Article 17 of the ICCPR, extends to include appropriate regulatory frameworks so as to govern against arbitrary interferences with an individual's right to privacy, where the Criminal Procedure Act fails to provide any legal framework for the voluntary disclosure of personal data by private entities to public authorities, it is submitted that they have failed to provide the protection it is their obligation to provide under Article 17.2.
So does this mean you're conceding the fact that the state in itself lived up to its obligation to respect these rights? Because you're claiming that it's a violation of a positive duty.
Your Excellency, thank you for the question. I'm not conceding that they failed to meet their negative obligations. I am merely making the point, in addition, that they also failed to discharge their positive obligations. Your Excellencies, turning to the second of my two submissions, namely that the interference was carried out in such a way as to be both unlawful and arbitrary. I've begun to touch on this question of lawfulness, and I would just like to make a submission in the round. The test for lawfulness, per General Comment number 16 at paragraphs 3 and 8, requires that an interference must be carried out on the basis of domestic law. Said domestic law must, and this is important, specify in detail the precise circumstances in which an interference may be permitted. The Syrian government obtained no warrant, as we are told in paragraph 24 of the facts. In failing to do so, they failed to comply with what could have been a legal basis in domestic law provided by the Criminal Procedure Act. Should Your Excellencies lend credence to the argument made by counsel for the respondents before the Syrian Appellate Court, namely that this was a question of voluntary disclosure of data, it is submitted that the Criminal Procedure Act failed to meet the requirements of the quality of law limb of the test stated. Specifically, it failed to specify in detail the precise circumstances in which an interference could be carried out.
Counsel, this goes back to my initial question. Are you questioning it on grounds of application or per se? Because if you're questioning the validity of the law, then this wouldn't be an as-applied case.
Your Excellency, might I submit that if you're questioning the validity of the law, that kind of overtakes an as-applied case in the sense that the as-applied case fits into the validity of the law. In which case, I might correct my earlier answer to your question and say that I am challenging this both on an as-applied basis and the law specifically. Thank you, Your Excellency.
Thank you for the clarification.
I would just submit under this question of lawfulness that an ask first, compel later approach is not good enough, where there is singularly no transparency about how voluntary private to public disclosures will be made. Personal data is not something that once out there can be put back in a box. A consequence of this is that the careful balancing act that must be carried out in order to assess the necessity and proportionality of interfering with an individual's right to privacy must be carried out before and not after the release of personal data, and should be overseen by an independent judicial authority. Your Excellencies, a lawful interference may still be arbitrary, that is, unless it is reasonable in the circumstances of the case. As we are told in the Human Rights Committee decision of Tunin in Australia, reasonableness requires an interference to be both necessary and proportionate. Your Excellencies, I will concentrate my submissions on the question of proportionality. It is submitted that the interference was not proportional, where proportionality requires the following four-part test to be met. First, there must be a legitimate aim. Second, there must be a rational connection between the measure and the aim. Third, there must be minimal impairment with the individual's right to privacy. And fourth, there must be a fair balance struck between the aim and the right. Your Excellencies, the applicant is willing to concede that the state met its obligations under the first and second limb of this test. It is submitted, however, that they failed fundamentally where it comes to the third and fourth. I will turn first to the question of minimal impairment with the individual's right to privacy. And I have 2 points under this. The first, it has been clarified that minimal impairment means the least intrusive measure. It is well established that measures involving judicial oversight are less restrictive than those that have no such supervision. Where the prosecutor's office failed to obtain a warrant, they failed to adopt the least intrusive measure available to them. My second point with regards minimal impairment is that the state did not ensure that this was a minimal impairment where its request was made for all personal data pertaining to X and A and B, again per paragraph 24 of the facts. As established at paragraph 64 of the 1984 European Court of Human Rights decision in Malone and United Kingdom, the scope of a request is key to determining whether it is arbitrary. Fishing expeditions and requests for all data are widely considered to be a disproportionate interference insofar as they are excessive and not limited only to what is adequate and relevant to the achievement of a legitimate aim pursued.
Do you have any other examples of cases that you could provide to the court, other than the one that you just mentioned, that we might consider in this current case?
Your Excellencies, I might also suggest and the United Kingdom, which is another European Court of Human Rights decision, and I might point you in the direction of the Council of Europe's Cybercrime Investigation and the Protection of Personal Data and Privacy discussion paper of 2008, specifically at page 50. For these 2 reasons, it is submitted that the state failed to meet the minimal impairment requirement of the proportionality test. Also under proportionality, as you will recall, is the requirement that there be a fair balance struck between the aim and the right. In making this assessment, it is crucial that the court have in mind exactly what is at stake in striking such a balance. As far as X and A and B's right to privacy are concerned, it is imperative that the court take seriously the weight that ought to be afforded to the right to privacy in the context of personal data held by private actors in relation to online communications app. The reasons for doing so are twofold. First is the nature of the data that we entrust to such online communication platforms. With regards persons A and B specifically, we are not merely dealing here with a string of numbers that makes up a telephone number. What we are dealing with is a key with the capability to unlocking a potentially limitless array of personal information about A and B as individuals. In combination with other personal data points, a telephone number can quite easily reveal a person's social network, historic and real-time movements, and, as in the instant case, political and religious inclinations and beliefs. In X's case, the personal data required by the Syrian state provided the government with the key to discovering not only X's identity, but also his opinions with regards an ongoing socio-political and religious debate in Syria. In this, it is necessary to recognize the importance of the right to privacy to exercising other fundamental rights, such as the right to freedom of expression as protected by Article 19 of the ICCPR, and the right to freedom of conscious thought and religion under Article 18 of the ICCPR. You'll remember that I said I had 2 points as to why you should afford appropriate weight to the right to privacy. The second of these 2 points is the growing evidence of ongoing government misuse of its citizens' personal data. In 2018 alone, the European Court of Human Rights heard in the cases of Privacy International and others in the United Kingdom, and Big Brother Watch and others in the United Kingdom, about the UK's flagrant and untrammeled exploitation of its citizens' personal data. Revelations made by Edward Snowden demonstrate that this is not a problem unique to the UK. Before concluding, I would like to draw Your Excellency's attention to just one further consideration with regards to the proportionality of the state's interference with A and B's right to privacy. It is noted that in assessing the proportionality of an interference, the European Court of Human Rights has taken into account the effect of the interference in question. Authority for this can be found in Lustig and Prine and Beckett and the United Kingdom. As specified in paragraphs 12 to 13 of the facts, the Soraya First broadcast channel acted as an important platform for democratic participation, not least in response to the government's own announcement that it was holding public consultation on what was ultimately enacted as Section 220 of the Criminal Procedure Act. Where this channel acted as such an important platform for democratic participation, the effect, which was the blocking of the Soraya Verse channel without notifications to subscribers or broadcasters, points towards the disproportionality of the measure adopted by Soraya. Your Excellencies, it is therefore the applicant's request that you find that Soraya's actions both amounted to an interference with X and A and B's right to privacy, and that said interference was both unlawful and arbitrary. Thank you, Your Excellencies.
If it pleases the court, my name is Emma Rowland, and I appear as counsel for the applicant. As my co-counsel, Ms. Eccles, has explained, I will be speaking for a time of 22 minutes and addressing Soraya's violation of X, A, and B's right to freedom of expression under Article 19 of the International Covenant on Civil and Political Rights. The restrictions in question refer firstly to Soraya's prosecution and conviction of X under Section 220 of the Sorayan Penal Act for his pre-recorded expressions on the 16th and 28th of February, and secondly to A and B's prosecution and convictions under Section 300 of the Sorayan Penal Act. This is a case where the applicants were engaged in an important political discussion on the role of the Anda minority within Soraya. Their participation in a public discussion has been met with an invalid restriction on their right to freedom of expression. For a restriction to be valid under Article 19.3 of the International Covenant on Civil and Political Rights, it must be provided for by law, pursue a legitimate aim, and be both proportionate and necessary to the legitimate aim. We submit that the restrictions imposed by Soraya on X, A, and B were neither provided for by law nor proportionate or necessary to the legitimate aim. Your Excellency's General Comment number 34 makes clear that the applicant's case will be proved if they demonstrate that the restriction in question did not meet any one of these limbs. Your Excellencies, the applicants submit that the most important issue before the court today is the proportionality of the measure imposed by Soraya, and as such I will structure my submissions as follows. I shall first address the proportionality of the convictions of all the applicants, before turning to why it was not necessary, and finally proceeding to why it was not provided for by law. If your Excellencies have no preliminary questions, I shall move on to the first submission, that the prosecution and conviction of X, A, and B was not proportionate to the legitimate aim. General Comment number 34 at paragraph 33 says that proportionality requires a restriction to be appropriate to achieve their protective function, be the least intrusive instrument amongst those which might achieve their protective function, and that they must be proportionate to the interests protected. Your Excellencies, I will first address how the measure imposed on X was disproportionate, before turning to A and B. We submit that the criminal prosecution and conviction of X by Soraya was disproportionate for 3 reasons. Firstly, whilst we accept that the state was pursuing a legitimate aim of protecting the Anda minority, a religious minority, we submit that it cannot be forgotten that X also had a right to manifest his religion. The right to manifest one's religion in Article 18 of the International Covenant on Civil and Political Rights is heavily dependent on the right to freedom of expression, as explaining the teachings of one's belief is an inherent part of manifesting one's religion. By commenting that the divine Son is under threat as many who see the light are now turning to darkness, X was clearly expressing his own religious views, and as such, the restriction imposed not only affected his right to freedom of expression, but also his right to freedom of religion.
But where do we draw the line between a legitimate expression or a legitimate form of religious practice or opinion and a form of incitement for violence?
Your Excellency, we would like to highlight that it's in this background of exercising one's freedom of religion that we ought to view X's statements, and that we would submit that they did not amount to the exercise of incitement for violence.
Sir, may I interrupt you? Could you please quote the speech, remind us the speech of the statement of Mr. X?
Of course, Your Excellencies. X's statement on the 16th of February was, "Soraya is under a dark cloud. Those from behind the seas have come to this bright land to bring gloom. The divine Son is under threat, since many who see the light are now turning away to darkness. Today the true sons of Soraya must rise against the unlawful actions of the sightless. We shall strip them of their blindfolds and force them to see the light, and if they refuse to abandon their ways, they will incur the wrath of the sun." Your Excellencies, in light of this expression, we would submit, addressing directly Mr. President's question on to what extent it amounted to the advocacy of hatred, that we must examine X's language. X starts the speech with obvious metaphors. In paragraph 16, which I've just read out, we're told that he referred to Soraya as being under a dark sun, and said that many who see the light are now turning away to darkness. By starting the video message with such obvious metaphors, we submit it's clear the entire message was intended not literally, but as one extended metaphor.
Would you say then, "we shall strip them of their blindfolds" extends to a metaphor?
Your Excellencies, we would submit in the context of the start of the submission that where light is consistently used by religions to express how their faith is the one true faith, it should be seen in the context of a metaphor. Yes, Your Excellency.
Councillor, what were the effects of this statement? What were the incidents between minors?
Your
What
Excellency.
happened after this statement was published?
Following the statements issued by X, there was a live video recording. The live video recording we submit should not be attached to X's statements and should not be construed as part of his expression, because he would not have been able to control the impact of the expression. However, following the live video on the 16th, there were a number of other videos which recreated the live section of the video and were reproduced up until the 28th of February according to the fact pattern.
But did Mr. X basically thanked his followers for doing these acts? I think it was in the end of February, right? After this incident, there was a statement published by him.
Yes, Your Excellency, there was a statement published on the 28th of February. Once again, I would like to highlight how it was a pre-recorded statement, and thus in determining the proportionality of the measure imposed on X, where we are unsure as to the date at which it was recorded, the ambiguities in the facts suggest that the measure was improportionate that was proposed on X, and we cannot draw conclusions about X's intention relating to that video. Intention, Your Excellencies, is a critical aspect in establishing if a speaker's expression amounted to the incitement of discrimination, hostility, or violence as per the Rabat Plan of Action. Your Excellencies, turning back to X's expressions and the use of metaphors.
Counsel, about the use of metaphors, is that an absolute defense? Could you perhaps elaborate or address international jurisprudence such as that by the ICTR when it comes to the use of analogies and incitement to hatred?
Your Excellency, I cannot draw on... Sorry, did you refer to the Inter-American Court of Human Rights?
No, the International Court of International Criminal Tribunal for Rwanda.
Sorry, pardon.
Because you've twice cited metaphors as a defense.
Yes, yes.
However, analogies is not a pure defense when it comes to speech. In fact, we have seen this before. One could refer to a group as cockroaches and call for genocide, and that is indeed seen as unprotected speech. So how do we reconcile Prosecutor versus Nahimana with your claim today?
Your Excellencies, from international jurisprudence, which does reference the use of metaphors as addressing the proportionality of the measure, I'd like to draw your attention to the case of Karatas and Turkey, which was a Grand Chamber decision of 1999 from the European Court of Human Rights. In this case, the case concerned the prosecution of an author who had used poetry to criticise the Turkish state. Some of the poetry read as follows: "The young Kurd shall take vengeance. I invite you to freedom, to death in these mountains. In this sacred spring we march." And the court held that the prosecution of the author was a violation of his rights. And at paragraph 52, they noted that even though some of the passages from the poems seem very aggressive in tone, and to call for the use of violence, the court considers the fact that they were artistic in nature, referring to the use of metaphors within the poetry, made them less of a call to an uprising than an expression of deep distress in the face of difficult political situation. Thus, whilst we do not submit that the use of metaphors is an absolute defence, we would submit that they are indicative of the intent behind X's language, and secondly, where there is ambiguities in the language through the use of metaphors, we would submit that it lends itself to a conclusion that the criminal conviction of X was disproportionate. Now, Your Excellencies, even if you are not with me on the point about the language used not constituting hate speech, I would like to draw your attention to the case of Mohammed Rabai in the Netherlands, where the committee acknowledged that the requirement of being prohibited by law under Article 22 of the ICCPR can be satisfied by civil measures over criminal measures. This suggests that for multiple reasons, that the criminal conviction of X was not the least restrictive measure that could have been imposed. Your Excellencies would submit that where measures such as notice and takedown procedures could have been used as an alternative measure, and that the criminal conviction imposed on X was not the least restrictive. Such measures could have been targeted at specific actions that allegedly constituted hate speech, and thus demonstrates how Sarai did not pursue the least restrictive measure. Your Excellencies, we also submit that the measure imposed on X was disproportionate because of its wider effect. Criminal measures have a greater effect of discouraging discussion on matters of public interest than civil measures, because of the greater stigma attached to them. In Gündüz in Turkey, a chamber decision from the European Court of Human Rights taken in 2003, the applicant had made derogatory statements about those who advocated secularism in the context of a live television broadcast. The court held that the criminal conviction imposed on the applicant was disproportionate, and in their reasoning they said the topic was widely debated in the Turkish media and concerned a matter of general interest.
But is that the situation we have at hand? Was a criminal penalty actually imposed?
Your Excellency, are you referring to a criminal penalty being imposed on X or imposed on the applicant in Gündüz in Turkey?
In the case at hand.
A criminal penalty was imposed on X, however, we would submit the fact a criminal penalty was imposed was what makes the restriction disproportionate, because it had the effect of discouraging discussion on a matter of public interest within Soraya. We know this from paragraph 10 of the facts, which highlights how the Soraya First Group were part of an ongoing debate on the role of the Yanda community Soraya, and that over 30,000 people had signed a petition created by the Soraya First Group. Therefore, where the criminal conviction of X not only impacted his right to freedom of expression, but also had a chilling effect on the rights of freedom of expression who shared the concern of X on the role of the Yanda community in Soraya and immigration in Soraya, that the criminal measure was disproportionate.
Are you able to explain to the court then what sanctions were imposed on X, and then answer. Can you answer that first, if possible?
A suspended sentence of 2 years was imposed on X.
And what was the maximum sentence that could have been imposed on X?
A imprisonment term of no more than 5 years, or a fine of no more than 1,500, or both.
So would you say that a suspended sentence then of 2 years is, or would have less of a chilling effect than an imprisonment of 5 years, for example?
Your Excellencies, whilst we would accept that a custodial sentence of 5 years would have been less restrictive than a suspended sentence, we'd like to highlight you to the case of Dmitrievsky in Russia and also Jerslid in Denmark, both cases of the European Court of Human Rights, where the court considered that the fact a criminal measure was used was in itself sufficient to create a chilling effect on the exercise of freedom of expression, and as such, it's the fact a criminal measure is used which makes the restriction imposed disproportionate. Your Excellencies, turning to the proportionality of the conviction and prosecution of A and B, we submit that the conviction and prosecution was disproportionate because A and B did not advocate hatred that constituted incitement. Both the Camden Principles on Freedom of Expression and the Rabat Plan of Action indicate that advocacy requires intent to promote hate.
And what authoritative force do these citations have for this court?
Your Excellencies, they are not binding on the present call. However, both were formulated in consultation with prominent experts on human rights treaties, and as such, we submit they have persuasive weight. The Rabat Plan of Action, however, was also used in the case of Alenkina and Russia on the European Court of Human Rights. Firstly, whilst we do not concede that X engaged in hate speech, we submit that where an individual publishes speech or expressions which do constitute hate speech for the purposes of furthering discussion on a matter of public interest, the person disseminating the material cannot also be liable for hate speech. Authority for this comes from Jerslid in Denmark, a Grand Chamber decision of the European Court of Human Rights. In this case, the author was a journalist who interviewed a racist group called the Green Jackets. The journalist edited the video in question in order to show provocative aspects of the hate speech before broadcasting it on television. His conviction and sentence for aiding and abetting the dissemination of racist remarks was held to be disproportionate. The court commented that the journalist did not have the intent to promote hate, and further, and I quote, that punishment of a journalist for assisting in the dissemination of statements made by another person would seriously hamper the discussion on matters of public interest and should not be envisaged unless there are particularly strong reasons for doing so. We submit that where A and B were using the Seeing and Believing channel to engage in an important discussion on the role of the Yanda community in Soraya, that they cannot have had intent to promote hate, and rather that they were engaging in an important discussion. Secondly, we would submit that liability of A and B based on the copycat videos is disproportionate because they did not have the capacity to remove those videos. In Delphi in Estonia, a Grand Chamber decision taken in 2015 in the European Court of Human Rights, a case concerning the liability of a news portal for comments published on its site by third parties. The court gave particular weight to the fact, at paragraph 153 this is, that the news platform in question had the ability to remove the comments posted by the third parties. A and B, on the other hand, had no such control over the videos published from the 17th to the 28th of February. And as such, we would submit that the prosecution and conviction of A and B based on these videos is a disproportionate response, given they did not have the ability to remove them.
Counsel, you make it appear as if a dolus directus standard is the sole standard of mens rea when it comes to criminal law. Surely there's other standards. Could you perhaps distinguish the applicable ones here?
Of course, Your Excellency. So we would have intent to promote intention, which would require, an intention to do the act which is done, and recklessness, Your Excellencies, which could be knowledge of the facts and an awareness of the results which might ensue, and then there would also be negligence where someone was completely the consequences of the act were disregarded, Your Excellency.
And by which standard should we scrutinize the criminal law?
Your Excellencies, Section 300 expresses that one can be liable within Soraya for recklessly advocating hatred. However, we would submit that as the Camden Principles on Freedom of Expression indicate, that intention to promote hate should be the consideration in a proportionality of a measure imposed. For it is only because of the importance of the right to freedom of expression, where there is not intent to promote hate, a speaker should not be considered to advocate hatred that constitutes violence or discrimination, Your Excellency. If Your Excellencies have no further questions on proportionality, I shall move on to the issue of necessity. General comment number 34 explains at paragraph 33 that for a restriction will violate the test of necessity if the protection could have been achieved in other ways that did not restrict the freedom of expression. We submit that in the instant case, a criminal conviction was not necessary because, as I have alluded to, notice and takedown measures could have been pursued and would have been less intrusive, yet still would have achieved the desired result. In contrast, a criminal conviction, as Ms. Eccles has highlighted, led to A, B, and X being permanently banned from hire, and as such has severely limited their ability to communicate with others. If the court has no further questions, I shall move on to my final submission that the prosecution and conviction of all the applicants was not provided for by law. Kimmel and Argentina of the Inter-American Court of Human Rights at paragraph 63 explains that to be provided for by law, a restriction to freedom of expression must be formulated with sufficient precision to enable an individual to regulate their conduct accordingly. I will first address the prosecution and conviction of X before turning to A and B. Firstly, in the Indian addendum to the report of the Special Rapporteur on freedom of religion, laws identical to those in Section 220 of the Penal Act were criticised at paragraph 47 because they failed to clearly define what makes a conversion improper and thus bestow authorities with an unfettered discretion to accept or reject the legitimacy of conversions, as such individuals cannot regulate their conduct in order to ensure they are in compliance with the Act. Secondly, we submit that the Act itself was inherently vague. The phrasing, "no person shall convert or attempt to convert, either directly or otherwise," in Section 220 subsection 1, and in Section 220 subsection 2, the term force shall include the term force in the law includes a show of force or threat of injury of any kind, is that both terms are so open-ended that they offer no guidance as to what types of conversion are allowed under the Act. And as such...
Counsel, what would you say falls under the remit of otherwise then? So if you're saying that they're not precise, what would you say falls under that remit?
Your Excellencies, we would submit that all conduct would fall under that, and therefore it's so... or that, rather, Your Excellency, that it's so imprecise as to what conduct does fall under, that we cannot create a list of what actions would constitute conversion under the Act, that an individual cannot regulate their conduct.
Do you not think it's sensible for a state to draft such a piece of legislation broadly so that it can be interpreted broadly in the courts? Your
Excellencies, we understand that there needs to be an inherent vagueness in legislation so that it can be applied within cases. However, we would submit that given the vagueness throughout the entire Act, that cumulatively an individual is incapable of knowing when the Act will apply and as such cannot regulate their conduct. With this, I'd like to draw your attention to the term social excommunication, which we submit is that it's unclear what level of exclusion, be it total exclusion from the whole community or mere rejection by a few members of society, would constitute social excommunication for the purposes of the Act. Likewise, the term threats of divine displeasure, seeing that many religions believe in there being some form of divine displeasure for non-adherence, that there's an unclear boundary between what constitutes a threat of divine displeasure and merely explaining the teachings of one's belief to a non-adherent. And as such, would submit that when all of these terms are viewed together, the phrase or otherwise threat of an injury of any kind, social excommunication, that an individual could not conform to the Act or know when the Act would apply to their conduct.
Counsel, let's zero in on that a bit. You mentioned two things. First, that it would be impossible to provide a list of acts that are prohibited, but at the same time that vagueness is inherent. It's unavoidable. So where do we strike the balance? What is the Goldilocks standard here, if there were one?
I'm aware I'm out of time. Are you happy for me to answer your question?
Please.
Your Excellencies, we'd submit that a balance has to be struck between an inherent vagueness and being able to foresee when your conduct will fall under the Act. And we submit that because of as I've stated, the multiple elements of vagueness within the Act, that the balance was struck on the wrong side, clearly in this case, and as such it was a failure.
No, what I'm asking is, how would you have drafted this law? If there were a more specific way to do this, how would you suggest that be so?
Your Excellencies,
Do you have examples, perhaps?
in order to clarify the Act, the removal of phrases such as or otherwise threat of an injury of any kind would inherently make the Act far clearer. In that simple rectification to the Act would have made it far clearer and such an individual be able to regulate their conduct. Thank you, Your Excellency. Thank you, Your Excellencies.
May it please the Court, my name is Ilyana Algaya, and I'm joined today by my co-counsel, Mr. Jonathan Ronan. We appear in this matter on behalf of the Respondent. In addressing this Court, I myself will be making submissions for 17 minutes, followed by my co-counsel who will be speaking for 25 minutes. With respect, we would like to reserve 3 minutes for rebuttal if necessary. I will be addressing issue A and B. Your Excellencies, we submit to this Honourable Court that Syria's decision to obtain personal data from Haya did not violate neither access right to privacy nor the one of A and B. Your Excellencies, just imagine yourself in the situation of ANDA adherents. Syria is the country ANDA adherents fled to, a country which used to make them feel safe and wanted. Since X's statement on the social media platform Haya, ANDA adherents experience unpleasant assaults, and we are talking about experiencing physical and mental violence, and they emanate from everyone's fellow men. Respondents assume that it is the state a threatened and fearful person would rely on to take preventative measures against violence and assaults. Your Excellencies, our submissions regarding issue A will follow these main points. Respondents will argue that Syria's decision to obtain personal data from Haya cannot constitute an interference to access right to privacy. And even assuming it was an interference, it would have been justified, as firstly, it was provided by law, secondly, it pursued a legitimate aim, and lastly, it was necessary in a democratic society. Your Excellencies, Syria's decision to obtain personal data did not interfere with access right to privacy, as the lowest threshold for an interference is the mere collection of personal data. Data collection is the process of gathering and measuring information on targeted variables in an established system, which then enables one to answer relevant questions and evaluate outcomes.
Can I ask where you got that definition from?
Thank you for that question, Your Excellency. I'm referring to the case Malone versus the United Kingdom. It was a case that was held in front of the European Courts of Human Rights. And in this case, the judgment held that there was an interference by a public authority because there was a measure of interception. Your Excellency, both the storing by a public authority of information and the use of it constitutes an interference to one's private life. As we all know, the state of Syria did not collect X's personal data at all. Respondents would here like to stress that A and B voluntarily revealed X's identity, and this disclosure of information cannot constitute an interference. It must be standard practice to interrogate people in the context of a criminal investigation. Interrogating A and B can therefore not interfere with the right to privacy of a completely different person. If it pleases the court, I will now come to my second point. An interference would have been justified in any way.
Counsel, before you proceed to that submission, could you address the applicant's earlier arguments as to the categorical need for a warrant?
Thank you for that question, giving me the opportunity to elaborate on that. It is the respondent's submissions that the obtainment of personal data was lawful. The obtainment of A and B's personal data was lawful since a judicial warrant was not required, as it would only have been needed if Haya had not been willing to share the requested information. One of the most important points to make here is that when a prosecutor seeks to justify a warrantless search with voluntary consent, that consent can either be given by the affected party or a third party who had common authority over the investigated object. As Haya is the service provider, it is to be expected that, upon discovering illegal content on their server, service providers will inform the authorities of their own volition or willingly cooperate with law enforcement.
Could I just take you back a second, Counsel? So far I think you've mentioned one piece of European jurisprudence. I asked this of the applicant, so I want to ask it of you. What is your position, and what is your respondent's position in relation to the application of margin of appreciation in this current case?
Thank you for that question, Your Excellencies. As the judge, as you mentioned, the state has a certain margin of appreciation while assessing whether a right should or should not be restricted. The wider the scope of the right that is to be restricted, the bigger is the margin of appreciation. The margin of appreciation is an instrument that is created by the ECTHR, which allows the weighing of factors in a concrete case.
So then, you've mentioned that it is linked to the ECHR. Are you aware then, perhaps, of the contrasting view adopted by the Human Rights Committee in terms of the applicability of margin of appreciation when interpreting the ICCPR particularly?
Could you please elaborate on that question?
So, what I'm trying to ask you is what weight should this court give to margin of appreciation? Why should it find, what should its opinion of margin of appreciation be in this current case? Without giving you the answer, I can't really...
Thank you for that question. While the margin of appreciation might not be applicable in this case, it is still to be noted that we are talking about crucial violations of other human rights, especially of end adherence. Therefore, there is a need to restrict the right to privacy of X as well as A and B. If the court...
Counselor?
Yes?
Also, I have another question. You mentioned that there was no need for the warrant because third party willingly provided information. Do you think that it's fair to put this argument for the state? There's no possible obligation for the state to protect privacy of its citizens?
Thank you for that question. We need to keep in mind that Haya gave the information voluntarily, and that they even told the law enforcement that there was the possibility to get this information when they are posing a formal request. So in this case, Haya is the one who gave the information and even showed that they are willing to give the information.
But doesn't the state have a positive obligation to provide the legal system and guarantees for an obligatory legal warrant in cases like this? So we do guarantee the rights of all parties in this case of X and A and B, and also provide a possible remedy for them.
Thank you for that question. Again, it is to be stressed that we are talking about crucial violation of human rights, and in this case, the legal warrant was not necessary, as it is of outstanding importance to understand that Surya is undergoing cultural and societal change and conflicts, and acts, as his statement was viewed by over 250,000 users, has a high influence on the Syrian society. He chose to publish his statement on Higher, the most popular social media platform in Syria, which is used by approximately 19 million people. X therefore encourages a great amount of viewers to follow his example, and Syria had a reasonable expectation that violence would continue. This is the reason why the state of Syria is of the opinion that restricting X's right to privacy is a good price to pay in order to prevent future assaults and violence. By considering the fact that, and also many studies have proven so, online harassment can manifest in physical violence in reality, Syria had to assume the presence of a pressing social need to obtain access to personal data. Your Excellencies, in the context of proportionality, it needs to be noted that the right of ANDA adherents to practice their religion in peace and Syria's interest in the protection of public order outweighs X's right to privacy in this case. Public order is described as the principles of a peacefully and effectively functioning society. All in all, it's the absence of disorder. As X's statements led to further crimes, in result, disorder is exactly what the state of Syria is trying to prevent when it prosecuted X. Furthermore, one must bear in mind that X threatened the right to freedom of religion of ANDA adherents. As outlined in the General Comment number 22 on Article 18 of the ICCPR, the right to freedom of thought, conscience, and religion includes the freedom to manifest religion or belief in worship and the wearing of religious symbols, such as the blindfolds. As we all know that ANDA is a philosophy that is associated with the wearing of blindfold, it is protected by Article 18 of the ICCPR. Syria had to restrict X's right to privacy as he created an unsafe environment for ANDA adherents to exercise their religious freedom, as many people followed his request to, I quote, strip them of their blindfolds.
But Counsel, can we truly argue that X caused the violence? He was speaking, as pointed out by the applicants earlier, in analogy, so they argue. And it says here that they would incur the wrath of the sun, which doesn't seem to invoke any literal meaning.
Thank you for that question, Your Excellency. I would like to quote one sentence of X's statements. We shall strip them of their blindfolds and force them to see the light. This is clearly an incitement to use violence and force against ANDA adherents. It can't be seen as a metaphor.
If we look at that one line, perhaps, but if we look at the entire paragraph, then it goes to show that there is some Shakespearean license being exercised here. So why then should we take this as the cause of the violence?
You mean the first sentence I just quoted?
No, the entire statement of X.
Okay.
Just another one. What are the other factors that we should take into account? Not just his statement as it is, but what are the other factors that will actually contribute to prove your point about inciting violence?
Thank you for that question. Let me first elaborate on the question that your judge made. It is to be said that after the video the broadcast was launched on the social media platform Higher, similar videos occurred on the social media platform where we can see people in the streets of Sun City physically assaulting other ANDA adherents, and they were chanting "Seeing is believing," which is the name of the channel, the broadcast channel. So we can see a link between the statement and the broadcast and the assaults that followed the broadcast. Also, the sentence, if they refuse to abandon the ways, they will incur the wrath of the sun, is also not be seen as a metaphor, as we don't really know what will be the wrath of the sun, but it can be said that it is something like violence. If it pleases the Honourable Court, I will now come to the respondent's submissions regarding issue B.
I'm sorry, you have to elaborate on that for us, please. What do you mean it could be something of violence?
Thank you for that question. The wrath of the sun might be something referring to the religion, but in the first sentence, he incited to violence. In fact, we can assume that the wrath of the sun will be something that is connected to that violence he is incited. Our submissions regarding issue B, regarding A and B, will follow these main points. Respondents will argue that Syria's decision to obtain personal data from hire was justified, as firstly, it was provided by law, secondly, it pursued a legitimate aim, and lastly, it was necessary in a democratic society. As we've discussed before, the obtainment of data was lawful since a judicial warrant was not required. Your Excellencies, respondents would like to state that the decision was necessary as it corresponded to a pressing social need and was proportionate. It is of paramount importance to mention that A and B's broadcast channel provides a platform with 100,000 subscribers. That means acts can encourage 100,000 people to assault under adherence, and the assaults will be rising as the video can be downloaded and uploaded on different platforms. It is just a fact that we don't know how many people will be encouraged to follow access requests in the future. At this point, it is again to be stressed that online and offline violence are interconnected. This is the reason why preventative measures can target either form of violence. Prosecuting A and B can therefore effectively prevent violence against under adherents. A and B themselves took actions to ensure a higher viewing rating. The social media platform has a so-called ping function a broadcaster can use to proactively alert their subscribers whenever a broadcast is about to begin or has begun, as A and B did. This, Your Excellencies, clearly shows that A and B contribute willingly and actively to spread access assaults. As a result of this broadcast that was hosted on their channel, it had become increasingly violent for under adherents to wear their blindfolds in public. In context of proportionality regarding issue B, it is to be mentioned that Syria acted to fulfill its duty to protect minorities, as mentioned. The obtainment of personal data was the least intrusive measure, as any other effective investigative measure would have been more intrusive to A and B's right to privacy. In conclusion, Your Excellencies, respondents would like this honourable court to be aware of that the right to privacy is not an absolute one. Every person has human rights that are enshrined in their personal dignity. Human rights are vital, especially in a democracy. The government cannot leave even one individual alone. To finish our submissions regarding issue A and B, respondents would like to quote the preamble of the International Covenant on Civil and Political Rights. The ideal of free human beings enjoying freedom from fear can only be achieved if conditions are created where everyone may enjoy his civil, cultural, and political rights. With that in mind, Syria had to restrict access as well as A and B's right to privacy in order to guarantee human rights such as the protection of minorities or the right to freedom of religion of under adherents. Thank you for your time, Your Excellencies. At this point, if there are no further questions, my co-counsel will be continuing the respondent submissions.
May it please the Court? My name is Jonathan Ronan. I appear on behalf of the respondent, the State of Syria, addressing issues C and D. Your Excellencies, we submit to this honorable court that Syria's prosecution and conviction of X, A, and B did not violate their right to freedom of expression under Article 19 of the ICCPR. I will be speaking on the matters of issues C and D for 25 minutes. Your Excellencies, the right to freedom of expression is a crucial right, yet not an absolute one. It may be restricted by Article 19, paragraph 3 of the Covenant. With regard to issues C and D, the prosecution and conviction of X, A, and B were lawful, pursued a legitimate aim, and constitute necessary measures in Syria's democratic society. Therefore, they complied with the admissible restrictions of Article 19, paragraph 3 of the Covenant.
Counsel, can I just ask you a question before you start your submission? So you mentioned Article 19 so far. Can you please cite other pieces of legislation that the court might rely on in addition to Article 19?
Excuse me, Your Excellency, could you elaborate on that question?
So what other instruments might this court consider in addition to Article 19 of the ICCPR?
Your Excellencies, we submit that this court considers not just Article 19 of the ICCPR, but also Article 18 of the ICCPR and Article 20, paragraph 2 of the ICCPR.
Any other instruments other than the ICCPR?
Your Excellencies, throughout my pleading, I will be referring to cases of the ECTHR and the UN Human Rights Committee.
And what's the relevant legal instrument within that jurisdiction that you might want to point the court to?
Your Excellency, could you repeat that question, please?
So you've mentioned correctly articles referred to under the ICCPR, but you haven't noted the other articles that you might want to reference from perhaps European jurisprudence, which you correctly mentioned.
Your Excellency, we would like to address to the ICCPR as this is a case. Your Excellency, I just remembered in the European Convention on Human Rights, there is a similar law provision to that of Article 19 of the Covenant.
And that is?
Article 10 of the European Convention on Human Rights. May I proceed? Hence, Your Excellencies, the prosecution and conviction of X, A, and B can by no means constitute a violation of the respective right enshrined in the Covenant. May it please the Court. Respondents will now proceed with their first submission, which presents issue C. Your Excellencies, there have been many examples of religious violence in the past. Their devastating impact includes the deaths of many victims. Victimized groups include the Rohingya Muslims in Myanmar and the Christians in Armenia. All of the violence was rooted in the absurd and vicious intentions of certain individuals. Against all odds, large parts of the population took on their intentions and realized them. This resulted in hostile conditions that were previously unimaginable.
But Counsel, surely we can't compare the potential genocides of the cases you mentioned and a domestic crime of hate speech.
Your Excellency, I would like to stress at this point that this is the onset of religious violence, of potential religious violence. Religious violence always starts small. We cannot expressly say that religious violence will not occur. And that's why it is for the state that it takes preventative measures so that it prevents any resulting powerlessness of the authority. Your Excellencies, history may not repeat itself. Crucial for this is, as I mentioned, an alert and resistant state that protects all people, especially minorities. Your Excellencies, this brings us to Syria in February 2019. There, the next case of religious violence was in the making. On 16 February, Applicant X, behind a mask and under the name of the Sun Prince, delivered a more than just threatening statement in which he posed the Antum minority as a serious threat to Syria and its majority religion. As a result, Applicant X's intimidating statement incited Syrians to impose forceful conversion on other adherents. Over 100 videos pertaining to X's statement surfaced on Haya in the following 10 days. They featured abusive and violent encounters with other adherents. One of the victims, S, reported that after his blindfold was forcibly removed by masked individuals, he was subject to hostility and exclusion from the Syrian faith due to his religion. Consequently, he felt pressured to change his faith. He could not freely exercise his religion anymore. Your Excellencies, this is a symptom of the onset of religious violence. If Syria had not acted against X's injustice, the situation of the Anta minority would have most likely escalated. Your Excellencies, the prosecution and conviction of X therefore prevented the outbreak of religious violence toward Anta believers. On this basis, Your Excellencies, Syria prosecuted and convicted Applicant X on the legal grounds of Section 220 of the Syrian Penal Act. Section 220 corresponds to Article 18, Paragraph 2 of the Covenant, which prohibits any coercion that impairs the right to freedom of religion of others.
Can we just go back to Section 220? I think it's fair to ask you this question. What do you think of the words directly or otherwise in subsection 1, divine displeasure or social excommunication in subsection 2, for example?
Your Excellencies, respondents at this point would like to stress that domestic law provisions are in need of flexible terms.
Flexible is an interesting word to use, perhaps in relation to those two subsections, I would say, would you not?
Your Excellency, could you further elaborate on the interesting aspect?
To say that directly or otherwise, and to say that divine displeasure and social excommunication are flexible terms is very true, but is that correct, that they should be flexible?
Your Excellency, at this point, respondents would like to bring forward that religions have a nature of their own. They are in need of wide scopes of definitions because there are religions of many kinds all over the world.
Councillor, but wouldn't that flexibility put it give chance and room for authoritarian regimes to use it to their purpose?
Your Excellency, could you repeat that question, please?
You argued that the law has to be flexible. Does not the flexibility or vagueness of the law allow the state to use its forces and powers against its citizens?
Your Excellency, that indeed is correct. May I draw your attention to divine displeasure and social excommunication as mentioned by the other judge? Divine displeasure describes religion. Social excommunication describes the effects of religion on the society. Throughout the past, there have been many diverse effects and many different kinds of religions. We cannot foresee how effects can be. And this is why state authority needs the flexibility to act in this case, in this specific case of Section 220 of the Syrian Penal Act.
Counsel, the court recognizes that there is the necessary reality is there does need to be some flexibility when it comes to regulation, but the rules are different when it comes to criminal law. The standard would be the nullius crimen stricta. How do you reconcile this vagueness that you yourself have recognized in your code and that internationally recognized standard?
Your Excellency, thank you for granting me this opportunity. May I draw your attention to the UN Human Rights Committee statement of Faurisson versus France. In this case, Robert Faurisson submitted statements on denying the Holocaust. France had the Gaissot Act, which prohibited statements. This was justified as it had the potential to target a religious minority and its well-being. If I may further elaborate on that. Your Excellencies, this is why the UN Human Rights Committee considered the criminal prosecution of Robert Faurisson as proportional, and we can, in this case, apply X, as his statements were threatening and had the potential to target certain communities of the society. That's why, Your Excellencies, as it was considered proportionate, we would like to submit it to the respective case. Thirdly, Your Excellencies, X's statement was marked by heightened tensions. We must bear in mind it acted as a catalyst to the already existing tensions. Syria had to act. As the European Court of Human Rights stipulated in Perinček versus Switzerland, that a criminal law response is required when a particular statement is marked by heightened tensions. Therefore, the context of X's statement is of significant importance for the fair balance between his rights and the rights of the Anta minority. X delivered the statement during a time of conflict between Anta adherents and Syrian nationalist groups. Syria had even amended its Penal Act with Section 220 due to the gravity of the existing tension. X's harmful rhetoric encouraged others to undertake discriminatory and hostile actions. Applicants addressed Gündüz versus Turkey, in which the Sharia law was proposed by an individual within a debate. However, they failed to mention that this particular statement was mentioned in a differentiated surrounding with other statements on the side that differentiated the particular statement. In this case, X submitted a singular statement and did not grant the viewers to have a differentiated argument with the particular subject. X therefore did not merely purpose the expression of an opinion, but he instead acted with full intent to trigger forceful conversions all across Syria. That is why he proceeded to thank his followers on 28th of February with, I quote, "for taking the message of light to the dark streets of Syria." Your Excellencies, the fact that Applicant X's inflammatory statement was marked by heightened tensions and did not purpose the expression of an opinion weakens his right to freedom of expression. Your Excellencies, this brings us to our third argument. We must be aware of the fact that Applicant X conveyed his statement on live broadcast further served to magnify its intimidating strength and atrocity. X had a special appeal to other Syrian believers by appearing as the Sun Prince, which refers to the sun, the religious symbol of the Syrian faith. The result was an expanded audience. In fact, 250,000 views were noted after just one day. The broadcast was displayed on Haya, a licensed public broadcaster used by 75% of the population. Haya is thus a media platform with a wide reach in Syria. This further enhanced the disrupting effects within the Syrian society. The conflict between Syrian nationalist groups and the Anta adherents peaked in the aftermath of the broadcast. Your Excellencies, the magnifying effect of the broadcast escalated the danger of X's statements. This amounts to a higher need of protection of the rights of the Anta minority. Moreover, X's statements fulfilled the requirements of hate speech as stipulated in Article 20, Paragraph 2 of the Covenant. This prescribes states to prohibit any advocacy of incitement to religious hatred. Accordingly, Syria rightfully acted against X's hate speech. Furthermore, Syria acted in compliance with the UN Rabat Plan of Action and the UN Beirut Declaration on Faithful Rights. They both contribute to the protection of minority groups against religious hatred. Applicants mentioned the great effects of criminal measures. However, respondents would like to bring forward that Syria's courts were aware of the exceptional value of X's right to freedom of expression. They refrained from imposing the maximum sentence fixed in Section 220 and even fully suspended his 2-year sentence. Your Excellencies, Therefore, we conclude that a fair balance was struck between the right to freedom of religion of the non-adherents and the right to freedom of expression of X.
Are you able to direct the court to any other jurisdictions that provide for such a sanction on an individual, such as a 2-year suspended sentence? Like you said, they were allowed to give a 5-year sentence, but they gave a 2-year suspended sentence. Are you able to point the court to any jurisdictions that might give an equivalent sanction?
Your Excellencies, there are similar law provisions in India, Pakistan, Bhutan, Nepal, and Nigeria. At this point, we would, as respondents, would like to mention one crucial difference between those law provisions and Section 220. If I may ask you, could you go to fact pattern 14? You will find in Section 220, paragraph 3, voluntarily returning to the forefathers' original faith or to one's own original faith. Now, these law provisions have been internationally criticized for protecting the rights of one's certain religion. However, as we can see here, it is referred to the forefathers' original faith, which is the Syrian faith, namely, and one's own original faith, which means that any faith can be construed under this act. Moreover, Mr. Ahmad Shahid, in his 2019 report, stressed that prioritizing a majority religion is permissible as long as it doesn't discriminate other religions. Your Excellencies, in this case, this becomes evident.
Counsel, the applicants earlier argued that despite the penalty having been suspended and a mere fine having been imposed, the mere fact that a penalty was brought into the conversation and, well, facially implemented upon the parties, creates a stigma that would in itself constitute some form of punishment and render a chilling effect. Could you please address this point?
Your Excellencies, this is the perfect opportunity for Syria to set a precedent case for Section 220 and send off a warning signal to Syria's society, especially amid the heightened tensions. In this respect, if I may proceed, the prosecution...
So you're suggesting that we should give deference to domestic court. So I've asked this of your co-counsel, I've asked this of the applicants again, and I want to ask your position on it. What's your position on margin of appreciation?
Your Excellencies, my position on margin of appreciation in this case is that the state has a wide margin of appreciation.
Okay.
If
Do you
we
want to elaborate on that?
Your Excellencies, the fact that there were heightened tensions extended the margin of appreciation. I previously mentioned the Gündüz versus Turkey case.
Yeah.
The fact that it was X's statement was singular and did not pose a differentiated debate further extended the margin of appreciation of the state.
I suppose my question is, are there any reasons why this court might not consider margin of appreciation to be applicable?
Your Excellency, there are reasons that you may not consider the margin of appreciation as it only applies to the European Court of Human Rights. This applies to all states in Europe that signed this respective treaty. However, we must note that the European Court of Human Rights is an important court, especially in reference to freedom of expression, and is recognized all over the world.
It's not recognized all over the world, though, isn't it?
Your Excellency, with this statement, I wanted to merely stress that other countries of the world take note of the European Court of Human Rights. In this respect, Your Excellencies, the prosecution and conviction of X were necessary measures in Syria's democratic society. X's hateful statement was toxic to the existing tensions in Syria. Thus, it was imperative to prevent further escalation of these tensions. This carried the potential to result in further religious violence. Respondents respectfully request the court to recognize the conformity of a prosecution and conviction of X with Article 19, Paragraph 3 of the ICCPR. May it please the court, if there are no further questions concerning the respective submission, respondents would like to enter their second submission. Your Excellencies, the statements of X in February 2019 jeopardized Syria's public order, and confronted the anti-minority with the onset of religious violence. The dramatic effects never could have reached this extent without the participation of A and B, the broadcasters of Seeing is Believing. Going back to 16 February, the day on which X made his harmful statement, A and B were the channel providers of Seeing is Believing. In order to bring attention to the live broadcast of X's statement, they pinged all their subscribers, whereupon the subscribers received a link to the broadcast. A and B, Your Excellencies, therefore fulfilled the requirements of Section 300 of the Syrian Penal Act. A and B's operation, Your Excellencies, on 16 February of the channel, on 16 February, created a hostile and demeaning environment for anti-adherents, and indeed also for visually impaired persons. The resulting avalanche of hatred divided Syria's society as certain parts of it had been targeted. Your Excellencies, this brings us to A and B's share of the imminent danger X created. Messages transmitted via audio-visual media, such as A and B's broadcast, have a wide-reaching effect. Audio-visual media even has the means to convey information that print media cannot impart, as stipulated in Jesselt versus Denmark of the ECTHR. Applicants also refer to this case, Your Excellencies. However, we must bear in mind that applying the respective case in reference to the statements shown is problematic, as Jesselt was a journalist and had a different level of responsibility. One such instance of victimization that resulted in Syria can be drawn from the case of T. She is a woman of Tarkan origin and visually impaired. After 16 February broadcast, she was approached by a group of masked individuals while traveling with a guide dog. The group shone flashlights into her face. She further experienced several occasions of verbal insults. T now reports that because of the broadcast, she has been forced to avoid public travel. Your Excellencies, this case demonstrates that once again, there was a desperate need for preventative measures by state authority. Syria's prosecution and conviction of A and B were lawful and constituted necessary measures in Syria's democratic society. Your Excellencies, in the interest of protecting Syria's public order and the rights of minorities, Section 300 of the Syrian Penal Act was the legal basis of the prosecution and conviction of A and B. It expressly qualifies the sharing of hyperlinks as an advocacy of hatred, of incitement to religious hatred. With regard to Article 20, Paragraph 2, ICCPR, this law provision even contains an advanced amendment: the punishment of reckless cause of advocacy. Your Excellencies, I would like to take you to Norway. Section 135A of the Criminal Code of Norway presents sanctions for measures which are comparable to the reckless cause of advocacy of incitement to hatred. As Norway is the highest ranked country on the Democracy Index, this demonstrates that the prevention of reckless cause of advocacy is featured in exceptionally democratic states. Your Excellencies, the prosecution and conviction of A and B were therefore lawful measures. Your Excellencies, I will briefly mention 4 arguments why a fair balance was struck between the prosecution and conviction of A and B with respect to the requirements of Article 19, Paragraph 3 ICCPR. Firstly, Your Excellencies, A and B had knowledge regarding the illegality of X's broadcast. This is assumed when the posting of links is carried out for profit, as determined in the European Court of Justice case of GS Media versus Sonoma, Netherlands. This becomes evident by the fact that they earned advertising revenue from the operation of their channel. Your Excellencies, A and B prioritized their business at the cost of Syria's public order and the well-being of Syrian minorities. They contributed to the effects of X's broadcast, even though they had the power to prevent it. If I may be granted another minute.
Yeah, you have 1 minute.
Your Excellencies, we also must bear in mind that A and B failed to distance themselves from the content and instead conveyed the thank you message. And we would like to stress that the advocacy of X's hate speech is a breach of Article 20, Paragraph 2 ICCPR. Therefore, Your Excellencies, the trial is all about choosing the right path. Do we want to turn a blind eye on X, A, and B's hatred and observe how they further divide Syria's society? Or do we want to prevent its harmful effects and thereby restore a peaceful coexistence of all Syrian people, regardless of what faith they adhere to? On behalf of the respondent, the State of Syria, we would like to thank the Honorable Court.
The judges will now deliberate upon the... My bad.
Your Excellencies, it is submitted that the counsel for the respondent has failed to meet the case put to them with regards the state's positive obligation under Article 17.2 of the ICCPR. This is specifically with regards to the law regulating the voluntary disclosure of data by private actors. The necessity of such regulation is demonstrated by the inconsistency of the state's approach to the necessity of a judicial warrant. Where the state failed to obtain a warrant when it came to its request of hire, it chose to do so with regards to the request made of mobile phone service providers from which it obtained the identities of A and B, as specified in clarification number 60. Is the court really to condone such an inconsistent approach, where the state would appear to be free to choose at whim the moment at which it applies for a judicial warrant? How are individuals such as X and A and B supposed to regulate their conduct accordingly in such circumstances? Your Excellencies, I would also like to direct your attention to the where the respondents sought to claim that Section 223 was not discriminatory in the interest of differentiating it from similar laws subject to the criticism of the Special Rapporteur. If Your Excellencies would look again at Section 223, you will notice that the section is constructed such that where an individual converts from, for example, Christianity to the Syrian faith, regardless of their original faith, there is no conversion. But where an individual converts from, for example, Christianity to the Anda faith, unless they were originally Anda, there is a conversion. Your Excellencies, it is submitted that it is this inconsistency which demonstrates the discriminatory nature of the provision. Thank you.
Thank you. Regarding the first point the applicants made, regarding the positive obligation to protect the right to privacy, it is to be noted that X's right to privacy are restricted, as he is to be considered as a public figure. Public figure is a person who voluntarily exposes themselves to the scrutiny of the general public. 100,000 viewers must constitute a general public to which X, in his character of the Sun Prince, voluntarily exposes himself. It is of no bearing that X did not use his real name or show his face. As X is a public figure, his expectation of privacy is diminished. He does not enjoy the same protection of his privacy as a private individual. Regarding the warrantless search Syria made to obtain A and B's personal data, it is again to be mentioned that the state did nothing else but posing a mere question to Hire. Hire's response that if someone wants it to publish user data, he or she needs to pose a formal request to shows that the service provider is generally willing to share information and also voluntarily did it in this case. Another point to make here is that Surya had in fact obtained a judicial warrant, as clarification question number 60 states. The actual names that corresponded to the telephone number were therefore obtained with the judicial warrant. Additionally, it is to be mentioned that the case would not have been any different if they had obtained a warrant, since this would not have been any problem. Your Excellencies, respondents would like to strongly emphasize that we are talking about crucial violations of human rights. It must be kept in mind that Syria is undergoing cultural and societal change and conflicts, and acts, as well as A and B, pose a threat to human rights that are in fact guaranteed by the ICCPR. Hypothetically made mistakes in regard of due process and warrantless searches do not change the fact that Syria was forced to act. It is the state's duty to protect its citizens and not leaving even one individual behind. Syria showed to people who are suffering from anxiety and unease that they are not alone, like any other democratic state would. Thank you.
Apologies for being over-eager a moment ago. The judges will now deliberate on our 12 complaints. Everyone is requested to leave and wait outside the courtroom for a few minutes. After the discussion, the judges will be providing their comments.
Do you guys want to stay?
Can everyone here stay?
Yeah.
And could the judges leave? It's much easier that way around. Thank you very much.
All right, so hello everyone. Hope we didn't keep you waiting for too long. We understand that it's been a long 3 days, and everyone's excited to hear how the results are. But before we proceed to that, we'll first introduce ourselves, and it's such a pleasure really to listen to everyone over the course of the competition. And as a judge, it was particularly a special occasion for me to share this panel with my two co-judges here, because apparently this is the first time I've shared a panel with an all Oxford Price bench. We were all members of Oxford Price teams over the past few years, from 2014 through 2016. So it was quite a unique experience being able to sit here with those who know how it feels to be on the other side of the podium. But yeah, with that said, I'll be passing it on to Olga to begin with some feedback before we share the results of the competition.
Thank you. Thank you again, both teams. Great job, well done. You spent so much effort and time. You had to spend on that, and as an alumni of Woodford, I know that, so you can trust me. Thank you. We're going to just give a short feedback as an advice for you, and hopefully that's going to be helpful for each of you. So first, Alice, thank you very much. Wonderful presentation, very eloquent, very well structured. I enjoyed listening to you. You dealt well with questions. The only thing I would love to hear more case law of different jurisdictions, because I think you just mentioned the cases against the UK. Yeah. And we would love to hear more of a diversity, especially since we are, in the Moot Court International Court, so that would be great. Otherwise, wonderful job. Emma also did a fine job with presentation. You dealt well with questions. I would suggest just a bit, brushing up on your presentation skills and keeping up a bit more confident. But otherwise, very well. Liliane, you did a wonderful job. Thank you for the inspirational presentation. And I could see that you kept up with all your structure and your papers. So even after our questions, keeping up with structure, that's a very important skill. So well done. And Jonathan also started off well. You were a bit thrown off with some of the questions, so I would just suggest you to work on that and to know well the legal instruments and mechanisms. They are essential. So even if you don't understand the question, just try to be not to ask for elaboration all the time, but there are certain questions that are pretty much straightforward. So otherwise than that, I think you have also a very nice presentation. Thank you.
Oh, would you like to introduce yourself to Devin?
Yes, I'm Olga Lewowska. I'm an alumni from 2015-16. My team from Queen Mary University of London, we were an octo-finalists in Oxford. So that was also a cool competition. And I know everything that you went through. I remember our final rounds, and we were actually a bit sad, but we were also relieved when we did not finals, because that was quite difficult to keep up, like 3 or 4 days of that competition in Oxford and eating sandwiches and just. That's my favorite part. Yes, no one knows it. We have favorite sandwiches in Oxford. So. Yeah. Anyway, and now I work as a lawyer at the European Court of Human Rights. So thank you for quoting so many case law. Thanks.
Hi guys, so I just wanted to say well done firstly. It is a daunting experience and I think both teams dealt with it very well. I should have introduced myself first. My name is Alex Willingham. Like Olga, I went to Queen Mary, but I was the year before her, so I was 2014. And then I obviously met her in 2015 and then we've seen each other each year since. We were semi-finalists in the competition in Oxford. It was a really great experience and I've come back pretty much every year to judge thereafter. I am a lawyer now. In 2014 I wasn't. And I'm a commercial lawyer by day. That's my job. So let's go down to individual feedback. I want to stress that everyone was very, very good. I will give each of you kind of one point that I think is constructive for you to take forward, because it's all well and good, all of us saying, oh yes, you were brilliant, but you're actually going to probably be presenting this again at some point, so there's something that you might want to take forward for each of you. So Alex first. So I thought your presentation style was excellent. You were very clear, you presented very well, you stood very still, which is a good thing to do. You didn't kind of wave your arms around or do anything along those lines. I thought you signposted excellently throughout. Strong points were considered in your arguments. The only thing that I would say is that, and I think we were in agreement on this, I think that you didn't really reference facts of the case as much as some other mooters might. And sometimes it's good to draw on those and refer the bench to them. And the other point was your rebuttal was very clear, as was your argument itself. But one thing that I think it's imperative to do in rebuttals is outline what you're going to say before you say it. Much like the argument of say it once, say it again, and then say it a third time, so that they actually understand what you said. And that's key to rebuttals, because it's such a short period of time. You have to say, this is what I'm going to say, and this is how I'm going to say it, and then you're done. So, Emma, clear presentation style throughout. Don't let the questions throw you. One of the things that you have as an advantage, and some people might view it as a disadvantage, but you are in control of the room when you're presenting. We will ask you questions, we might ask you leading questions, but you are actually guiding the judges, so take that as a confidence thing. And take that forward to kind of think, whenever you're up there and you may get thrown by a question, actually you're in control, you're the one that's guiding the bench. But otherwise I thought your presentation style was very good. So let's move to the respondents. If I'm pronouncing your name wrong, Liliane?
Yes.
Liliane, okay, fine. So you had a very clear presentation style, you conversed with the bench well, but again I'd say with your rebuttal that you didn't outline what you were going to say before you said it. So perhaps something going forward would be to do that. Jonathan, again, a clear presentation style. I wrote well signposted at the beginning, and you were well signposted at the beginning, but I think some of our questions, as Olga mentioned, did throw you. And I wasn't sure whether I liked the way that you said, could you please elaborate, because some of those questions were actually quite straightforward and didn't necessarily require elaboration. And it might have been a time kind of saving mechanism for you to go, actually, what am I thinking? What's the answer to this question? I hesitate at saying this, but if you don't know the answer to the question, say you don't know, because it probably looks better. But then the other answer to that is make sure we know the answer to the question. So I think that's it. I thought that the presentations overall were of an excellent quality. They're what I would expect to see later on down the line in Oxford. So well done.
All right. Thank you, Alex. So yes, my turn. So my name is Rafael Pangalangan. I was a member of the University of the Philippines Oxford Prize team in 2015. We took home the championship back then, and it was my first taste in the mooting world, first step into the mooting world. And my practice is in criminal law. I worked as a prosecutor for graft and corruption, so if you may notice, my questions are mostly ICL or criminal law related. I decided to pursue studies in both Oxford and Cambridge, and many of these feats were in fact thanks to Oxford Prize. So I'd like to congratulate everyone here for taking a first and great step into this network of superb human rights advocates. As to my comments of the presentation, I'll keep them general, so I'll be addressing both parties at the same time. The individual comments have been addressed by my co-judges. And as to a matter of form, I think everyone had great, just good speed. You were engaging, great eye contact. Same comment, don't be thrown off by the questions asked. And in fact, questions is a great chance to engage with the judges. A silent bench is one to be worried about. It means that chances are they're either waiting for something to probe into, and if there's nothing there, well, then perhaps there's something wrong. But as to the substance, I can't touch on substance in too much detail, so I'll keep this thin and abstract. But the tendency in moots is usually to approach the argument as if there's one side. If we're arguing for the applicant, we pretend that the applicant's right and the respondent's right. And I find that the categorical answer isn't usually the right one. We should appreciate the fine nuances of the question. I mean, something I've already mentioned to other teams before is if there were a bright line answer, that would be a rather terrible moot court problem to have. So rather than ignoring the debate, I would highly suggest that you embrace it, you engage with it, and you point out that, yeah, there is another point to be made, but I just have one that's better. And if you're able to do that, then you will deliver a not only successful but winning argument. So those are my comments, and generally congrats to all. And with that said, we now move on to the important stuff, I suppose, the results of the competition. And with that said, shall I have the pleasure of announcing? Okay. With that said, we are very proud to announce that the winners of the first North European Regional Competition of Oxford Prize is the Applicants. Team 104. So we'll pass the floor to Nevena.
Okay, I want to congratulate the winners and the runner-ups. So this, of course, means that you qualified for the international rounds in Oxford. But there are a couple of more things to do before we announce the others as well. So I first want to thank all the teams for being here. And I want to congratulate you all for all the effort that you put in the last couple of months preparing for this competition. It's been our pleasure having you here. And also I want to thank the judges, not only the final bench judges, but all the judges throughout these 3 days that were with us. So it's always hard to set up a new round. We don't have a lot of contacts, we don't know people, so this was a challenging thing, but definitely we are quite happy how it turned out, and especially because we had a lot of lawyers here from Paris, and also we had the international judges coming. So our Moot alumni circle is getting bigger and bigger, so we are very grateful for that. Also we have judges who came from UK, from Netherlands, from different countries, but without them, this competition wouldn't be possible. So let's give them a round of applause. So hopefully they'll come and join us next year as well, and hopefully some of you as our Moot alumni. Of course, I want to thank again the University Paris Descartes, because if they didn't provide us this space and all the support throughout these days, this wouldn't be possible. Professor Caroline Legofic, she was also the main contact person here. And last but not the least, I could have done it by myself, and without the help of Sivar here. So most of the work was done by her before we all gathered here. I'm going to proceed to and give each team the certificates of participation, and now I'm going to read out loud which team has which number. And then I'm going to ask Richard Dumbury, our long-term friend of the mood, to say just a couple of words to you, because he had judged a lot of rounds this time. So he knows it much better than I do in terms of how you all did. But I've heard you all the best. So team 101 is the University of Luxembourg. Team 102, University of Paris Descartes. 103, University of Oxford. 104, Queen Mary University of London. 105, Universidad Carlos III de Madrid, Spain. 106, Humboldt University Berlin. 107, City University of London. 108, University of Edinburgh. 109, University of Law, UK. 110, Law Society of Ireland. Richard, if you'd be so kind to join me here.
You want me to say something? Yeah. Hello. They've introduced themselves, so I thought I might introduce myself as well, because all I have, well, some people have asked me who I wasn't. But all you've had is some of you have had the misfortune of having me asking awkward questions and disrupting you. I should say I apologise if I can start. I'm sorry. My name is Richard. I was a very long time ago a criminal barrister, and I learnt my trade going up and down the magistrates' courts in the south of England, representing people in criminal courts, this, that, and the other. And a day-to-day existence in local first instance courts is the best way of learning advocacy. And it's a skill which you can then apply at every court, every jurisdiction that you appear in. But for one reason or another, I gave up the law, and then I wrote travel guidebooks, and then I became a journalist, and I specialised in investigations and interviews using exactly the same techniques we've been using here, but in a different format. And then I did a PhD in media law at about the same time the prize movie competition was being set up. And I, bizarrely, was the only person in the university who knew anything about media law or international freedom of expression law at that stage. So I hid myself to the prize movie. They've never been able to get rid of me since. So that's me. Comments on this round itself. It's been a very impressive round. It's the first round we've had in the northeast of Europe. And I've done a number of regional rounds and a number of international rounds in Europe. In fact, the first one I did, I think, was 2011, which was when you were in it. She was in a winning team, which she hasn't mentioned so far. So I've seen quite a few. And this was an impressive round. There were some very impressive pleadings from everyone. I was going to give you a couple of general points about some recommendations about what I want to do in the future. But most of them have already been said by the panel behind me. And I'm acutely conscious that I am the person standing between you and the revelation of who goes to Oxford, so I think I'm going to shut up in a minute. But I thought I'd make one real point, which is the best way of considering what a moot is that it's a formal and bizarre conversation. You are trying to persuade 3 people, and you are trying to persuade 3 people of essentially one thing. And from that, everything else should follow. It should follow what you're going to concede and what you're not going to concede. It should follow what tone you're going to adopt and what tone you should avoid. Ultimately, what you're trying to do is find out why they are concerned about your argument and meet those concerns. So when they ask you a question, don't be surprised, don't be fazed, don't be irritated that you're not going to be able to complete what you've written down. That is actually the core of the route. It's finding what their arguments are against you, dealing with them. And if, for example, you're a respondent, listen very carefully to what the applicant is saying and try and meet those arguments head on and deal with them. And after all, you should know what they are because you're preparing both sides. Be aware of the strengths and weaknesses of your own case and their case, and then be prepared to advance appropriate arguments in an appropriate way. So that's enough for me. I will hand you back.
Thank you. So our regional round, every regional round has several awards. So I'm going to give awards. We are giving awards for Best Memorial Runner-Up, and Best Oralist and Best Oralist Runner-Up. So Best Memorial Runner-Up goes to Team 101, the University of Luxembourg. And Best Memorials are from Team 103, University of Oxford. Best Oralist Runner-Up comes from the Law Society of Ireland team, and it's Ronan Finucane. And Best Oralist comes from Humboldt University of Berlin, and it's Jonathan Ronan. So lastly, as I said at the very beginning, the finalists are joining us for the international rounds in Oxford, and we have 3 more spots. So in no particular order, I'm going to invite teams 110, Law Society of Ireland, team 101, University of Luxembourg, and team 109, the University of Law. So once again, thank you very much. We would like to take a group picture in front of the building on the stairs, and afterwards in the room next door there will be a lunch provided, so we can all relax. Thank you.
Thank you.